Hi, I'm Debbie Moraes. Once again, welcome to Legal Matters, the program that's designed to address critical, sometimes contentious issues that are facing consumers and businesses today. It's legal information, practical solutions, and straight talk about a wide variety of issues that confront your business and your work life. We welcome, as always, from Audette, Bazar, Cordeiro, Grasso law firm in East Providence, Jackie Grasso and David Bazar.
Good afternoon.
And today, our topic is deadbeat dads, one of the latest epidemics nationally, and of course Rhode Island and Massachusetts are not exempt. Not to discriminate, there is such a thing as deadbeat moms also. There are now websites that have been launched to track both of them. You can post the name of one for help in tracking them down. You can even search for by name to have some help in locating them. So when a parent is ordered by the court to pay some child support and they continually fail to do it, they are commonly referred to as the deadbeat parent. That pejorative term is actually used in legislation in some states, and I guess it is often understood. The parent who falls behind in those child support payments, it can happen for a variety of other reasons too. They lose their job, they get sick, other things happen. But that deadbeat name is generally reserved for someone who has the means but chooses not to pay. So of course we want to get paid. Rhode Island has reported through the Providence Journal something like 29,000 cases, and collectively they want $291 million that's owed to them. Awful lot of cash. So today, as we usually like to get the straight answers from our lawyers, we'll have a few issues to debate. Set up the story. What happens with Rhode Island child support and Massachusetts child support? What's on the books?
Every state has, through their Division of Taxation, a child support enforcement agency. Rhode Island has one, it was mentioned in the paper, Massachusetts has one. Every state has adopted that. And what that agency is empowered to do is to collect and enforce child support orders. Unfortunately, the collection rates in Rhode Island tend to be low. Massachusetts is a little bit more aggressive because, as you read in the article last week, they post the photos on the wall, so to speak. Every time I go into court in Massachusetts, they have the most wanted person on the wall, and that was one way of tracking them down. I think Rhode Island tends to be a little bit liberal, more liberal in the situation.
That historically wasn't always the case. General Magistrate O'Brien, who recently retired, was on the calendar that was in charge of collection. He was very aggressive. We didn't need to post photos of anybody. All you needed to do was subpoena the folks in that owed the money. Master O'Brien would go through the files. He would pick out the first one where they owed considerable amount of money, send them to jail, and then the guys or girls would line up to make their payments.
Sent the message.
We were very, probably at the top of the list when he was on that calendar. Yeah. That's not to say the other judges or magistrates who were sitting on that calendar are lax. I think part of the issue is we're on really hard economic times, and that has a big impact on people's ability to pay.
But what people should know, too, is that through the Child Support Enforcement Agency, you are provided with an attorney at no cost to the individual. The only downfall is you're in line with 3,000 other people when you're trying to enforce a child support order. So it does take time, and your client may go back to court numerous times, not get anywhere, whatever, and they get just so frustrated, and they just finally hold their hands up and say, forget about it.
Right.
So there is some enforcement, but if you miss a payment, that doesn't trigger the problem, does it? Or does it? And what do you do if it does trigger
Well, it depends on how much of the payments have been missed. So, for instance, under the federal statute, failure to pay a child support order for more than $5,000, you could be looking at 1 year in prison. In Rhode Island, I think the limit is $10,000 before they'll start.
Before it becomes a criminal type of action.
A criminal type of
the word
action.
felony came into play there at $10,000?
Yeah. But other ways they can collect is by suspending your license, a driver's license, professional license in some cases, where that really hits home to somebody who's got thriving medical practice and all of a sudden loses his license for failure to pay
And
child
Jackie
support.
spoke about the person being entitled to an attorney. The person who's collecting this, trying to collect the support, the state doesn't necessarily represent but provides an attorney to enforce the rights. the person who owes the money, when they're facing jail, is actually entitled to have representation. When your liberty is at stake, there's an attorney that will be provided for you either off the list or through some other process.
Now, does this just apply to those who are in the poverty category with those FIP payments, the whatever those, you can go through those in a minute, but is everyone entitled to having free representation?
Sure.
Or is it just those who are
If somebody's on
indigent?
welfare and collecting some form of public assistance, in Rhode Island it would be, what is it, right care?
That's part of it.
That's
yeah,
part of it.
Yeah.
So anybody who is getting a public benefit has an obligation to disclose who the non-custodial parent is, because by law, our child support enforcement agency needs to seek out that person to be reimbursed for the cost that the state is paying.
There's many different funds that you can receive. There's the SNAP program, which
Yeah.
is the old food stamps. There's medical assistance. There's neighborhood health at one time, right care, any of those types of medical assistance. The state can come back after the non-custodial parent to get contribution towards some of those things. There's a daycare program where if you're receiving those benefits, the state's entitled to try to get compensation from the non-custodial parent. But going back to the prison thing, that's where you now have a right to an attorney, perhaps even if you can afford one, because it's actually based on an interesting case. The state brought somebody in who owed quite a bit of money, sent him to prison, forgot he was there. And he was there for 2 years before they realized that they should have brought him back to court for a hearing. And so based on that case, so that no one slips through the cracks anymore, the state provides attorneys to people who are facing the potential of a jail sentence over non-payment.
I would like for you to be able to talk about how someone decides, or how they decide what that payment is about. But when you're talking about incarceration, there's great heated debate about that apparently, because you've set up what looks to be a catch-22, whereas if you have someone who's in jail, how are they supposed to work, make money, pay the child support?
Well, that's why the states can only hold them for a certain amount of time, okay? I think it's the first time you're going in, they can only hold you for 30 days before you have the ability to return to court. And believe it or not, it is unconstitutional to hold somebody in jail who is poverty-stricken. So before somebody can be sentenced to jail for failure to pay child support, the judge needs to find that that person had a present ability to pay. If this person had no means to pay, maybe it be by illness or some type of tragedy in the family, they can't incarcerate that person.
The theory is you hold the keys to the jail. So in order to hold the keys to the jail, the person who's being sent, they have to have an ability to pay. Jail is being used as a coercive manner to try to force them to come up with the money that theoretically they already have the ability to pay.
And how do you prove ability to pay? You look at their finances. So they fill out a financial statement for the court, and with all hopes that it's been truthful. But if somebody says, Judge, I don't have an ability to pay, but they have a $50,000 CD in the bank, you're going to jail.
Right.
Okay? Because they can look at your assets.
Income and assets.
Yes.
Let's back up a minute. How does the court decide when, say, there's a divorce or separation, how does the court decide what is considered to be reasonable child support?
Guidelines.
Yeah.
Every state has guidelines.
Are they the same Rhode Island and Mass?
No,
No.
they're all different. They're all different.
You tell how Mass works.
Massachusetts, almost like Rhode Island now, with the income shared model. They just changed them about 5 or 6 years ago, and it's a complicated economical formula, but for the most part, they're almost like Rhode Island with the income shared model.
So-
plug it into the guideline sheet.
What we do in Rhode Island is you take the custodial parent's income on a monthly basis, the non-custodial parent's income, then you may deduct certain things like health insurance, if that's something that you're paying for to cover the family, or perhaps some other things, some bills that may be deductible from that. You come to a bottom line of what does each parent earn monthly, and there's a percentage now. If I earn $5,000 a month and Jackie's the mom and has $5,000 a month, we each earn 50% of that gross income. You then go to the guideline at $10,000. Here's what it is for 1 child, 2, 3. take the number and multiply it by the percent you owe.
So they've tried to make it objective as they possibly can. And what about if there's a shared custody situation?
Well, there's always the exception. A shared custody is, I'm assuming you mean shared physical.
Physical,
Okay.
yes.
So where each parent shares time with the child, maybe 3 days during the week with one parent, 4 days during that week with the other, and vice versa. You do have the ability to get an adjustment on the child support. It doesn't cancel out. A lot of people are under the misconception that because you have shared physical placement, you don't have to pay child support. For instance, if let's say the dad earns $100,000 a year, mom earns $20,000 a year, shared placement, okay? No child support, that's not fair because you have $100,000 here and $20,000 here, so the child is still without. So they would make an adjustment in that situation.
What you might do is take what the dad would pay to the mom had he not had any shared custody, what the mom would pay to the dad,
Yep.
and then the dad pays the
Subtract it.
difference in Jackie's example.
It's good to know that. What happens in the case that if someone understands how this system is supposed to work, but they like to beat the system? Most people, you would say, shouldn't try to, but how about the income that isn't documented, the stuff that's paid under the table?
Happens all the time.
Or they went to another state and another country, and so these problems of enforcement become much more complicated, don't they?
Yeah, well, years ago, we used to have a problem with jurisdiction. And what jurisdiction is the right of the court to reach a person and hail that person into the court so that they can be subject to our laws. So, for instance, if David never stepped foot in Rhode Island and I wanted to go after him for child support, under the old ways I could never get him into Rhode Island because there was no jurisdiction. There are exceptions. There's something called long-arm jurisdiction where if you had minimum contacts. But what the federal government did many years ago is they enacted a statute called the Uniform Interstate Family Support Act. That was designated to address that problem. So if David never stepped foot in Rhode Island, and I need to get child support, the courts don't care because we're going to still bring him in, and it may not be in Rhode Island. What Rhode Island would do through the child support agency is they would open a child support file, they would send it to Massachusetts through the UIFSA statute. Massachusetts would hail David into court in Massachusetts, and then they would establish a child support.
It's sort of like a compact between states.
Yeah.
If your non-custodial, non-paying parent is in your state, we can send the information through the state's attorneys that handle these things to make them enforce it in the other state.
How does the federal government get involved? I understand that there are times when this network or communication that's supposed to work as well as it's supposed to work, they might be able to find out when David needs to renew his license in another state. They might be able to get him that way, or maybe through his income tax returns or something.
That's all part of the enforcement mechanisms.
And how successful is that? Apparently, from what we've read, not very.
Well, correct, but there are other ways where you can pursue an arrearage. If the license suspension doesn't work, like David said, criminal prosecution. New hire reporting is important because then the federal government knows if this person is working. So employers are bound by federal law to issue a report that they have a new hire. And that even goes back to what Roberto Gonzalez was talking about last week with new hire reporting. Federal tax offset refund, so if somebody is working and there is a tax refund for the deadbeat dad, that refund's going to go right to the custodial parent.
And is that working now?
Oh, that does work.
I also think lottery winners that are large winners, they have a check for child support that's owed. In personal injury cases, when you settle a personal injury case, there's a Social Security check to see if child support's owed before the money's paid out.
Same thing for workers' compensation as well.
If you're working on behalf of the parent who is supposed to get the check but did not, at what point should that parent be contacting the Office of Child Support or you to do something about the situation that seems to be getting worse? Or when do you pull the trigger?
The sooner the better.
One check out?
Well, I would say...
One check out's a little soon.
That's a little soon. Maybe contact us and we send a letter, but if somebody's 6 months or more past due,
Right.
then you should contact Child Support Enforcement, open a file, or if you don't want to go through Child Support Enforcement, you can hire your own attorney. Volunteer lawyers are always providing attorneys pro bono.
If we have a family that has some substantial means and the non-custodial parents behind in child support, and it looks almost like it's intentional, I'm going to pay my Jaguar lease first and then all the other bills before I pay my child support, you might want to contact a private attorney and say, look, here's the order, he owes the money, he's got the ability to pay, he's just not paying, because that private attorney is going to be able to get this right into the court immediately, file the paperwork to get discovery out to say, here's all this guy's assets, here's the ability to pay, and really push that case. And if someone is in contempt of a court order, the judge has the right to assess attorney's fees against the person who is in contempt.
How do you determine who is in contempt?
Failure to pay, and you have to get a judgment, a finding from the judge that it was a willful failure. So the individual had an ability to pay,
You have to
but
put that?
refused not to. Yes, you have to put that on the record. You have to get testimony from the individual, and
The testimony would simply be, here's the court order, this is what the person was ordered to pay, this is what they actually paid, which is less than they were ordered to, and here's what they were earning during that period of time, and they had the ability to pay, they just chose not to or chose to pay other things first. If you prove those things, then you have willful contempt.
How about, let's discuss for a moment what happens if you're not paying but there's a legitimate reason. I stumbled across in my research that apparently if someone didn't pay, there's some penalty and it's accruing and it's interest. But how would someone know to make a call to someone to stop this, to have it modified so that some adjustment can be made? I lost my job, my hours were cut, I got sick, I got hit by a car.
A lot of times we see cases in our office where someone would come in who was served with a contempt action for failure to pay child support, and after we interview them for a while, we find out that the person was sick and was out of work for 6 months, never returned to court for a modification. So, you might say, well, you snooze, you lose, but there are ways that you can ask the court to modify that support order retroactive to when the actual incident happened.
Is that true? Because I read something about the fact that they generally don't do it retroactively, but they do consider it?
They will consider it.
The rule is...
Well, they'll figure a child support guideline
Right.
on what that person was earning at the time and factor it in.
Well, the rule
when the
is
incident
you
happened.
theoretically can't go retroactive beyond the filing date of your motion to modify. I think what Jackie's really getting at there is if you couldn't have paid, you're not in willful contempt.
Yes.
If you're not in willful contempt, they shouldn't send you to jail, they shouldn't punish you. You may still owe the money, but what we would do in those cases is to say when you're back on your feet and able to pay, you would pay a little bit towards that. Now, in fairness, if there was an illness and you couldn't have filed, I think is what Jackie's getting at, some
sense.
consideration should be given to that person's condition or situation. But the federal law has made it a little bit difficult for states to allow retroactive filings on anything dealing with child support.
Usually what I do is if somebody's collecting TDI, I'll ask the child support attorney to look at that TDI amount back to when the arrearage started and maybe calculate the child support from that day forward. There's still going to be an arrearage, but it's not going to be as hefty as it was
Right.
prior to the person being ill.
That sounds very reasonable. What can you suggest proactively? I read something about 10%. You mentioned that there's a reason to modify and somehow 10% shows up. Does that mean 10% in their overall income that's changed
No.
that says they should, how does that
What
work?
that rule is when you file a motion to modify, whether to increase or decrease child support, the rule of thumb is that there has to be a significant change of circumstances in order to modify, and 10% is generally considered to be the cutoff point. If it's more than 10%, it's a change of circumstance that warrants a modification. 10% of the amount of the payment.
So someone should contact Child Support Services first or their private attorney to...
They can go through Child Support Services, and there's a website online for every state, and they can actually access the child support worksheet, the calculator, and they can determine how much support would be paid.
Childwelfare.gov or something comparable?
State of Rhode Island has
And that does.
Yeah, Massachusetts definitely has one.
Tied to this, I guess in a different way, the issue of child visitation and child support. Would you address that a little bit?
There's no connection.
There's no connection.
If somebody can't afford to pay child support because they have no ability to pay whatsoever because of illness or physical handicap or whatever it is, doesn't mean they shouldn't be allowed to visit with their children. The judges should totally separate. It's not you pay, you see, you don't pay, you don't see, because you have to look at every situation individually. Now, could there be a tendency to say, well, look, you had the ability to pay, you're not paying, you should be punished? You're punishing the child. Always put the child first. This ability to pay and payment is a separate issue. If you don't pay, you should be punished for that by being punished financially or something like that, not by not seeing your child.
What the custodial parent will do at times is refuse visitation because the non-custodial parent's refusing to pay, and you can't do that.
And if there's a court order of visitation and you're doing that, now you're in contempt.
Actually, that was the part that I had come across about that distinction, that they were supposed to be separate entities, but that parent who's upset, aggravated, and decides to prevent it could actually be in worse standing than
Right.
having let that go.
You're punishing the child to get back at the ex-spouse who's not paying. It's not the way you do it.
when the couple is in front of the judge, does the judge make that perfectly clear? These are
Yes.
two mutually exclusive issues?
I would say so,
and-
sure.
Yeah.
Yep.
And they should know that,
Oh,
and
they should
remember
know
that.
Right.
Well, we as attorneys will tell our clients that as well.
That's just the way it is. Think about it from the child's perspective. The child doesn't care if mom or dad is paying child support. The child wants to see mom or dad. So that shouldn't be interfered with. If the person is able to pay and isn't paying, maybe they won't visit because they're locked up in jail for a little while. But that's the court's decision, not the non-custodial parent who's mad at the person who's not paying.
When you have an occasion to represent the non-custodial parent, how do you defend them? How do you manage their
Well,
case?
if it's for a child support arrearage, I start by determining why there was an
Right.
arrearage to begin with. And most of the time, it's because somebody had a loss of income,
An injury.
an injury or an illness, and they just didn't know that they couldn't return to court to modify. So that's where we start. And then we work with the other attorney, if it's a private attorney or if it's the state. Most of us can work together. And we try to come to a mutual agreement to establish an arrearage, okay? Because the arrearage might be $10,000, but if we can come to a mutual agreement where everybody's happy and set the arrearage at $7,000, then that's where it starts. But everybody has to be on the same page.
And is that something that is fought over or mediated, or
It could be mediated. If everybody agrees to it, then fine. But if one party doesn't agree to it, then you have to have your hearing before the judge, and the judge is going to make a determination as to the amount of the arrearage, and they're going to establish an arrearage order.
You set the arrearage, and then you have to determine if there's an ability to pay on the arrearage. So it's a two-step process in terms of how much do they owe, were they in willful contempt and not paying it, what should the punishment be if they are in willful contempt? If they're not in willful contempt going forward, how is the money going to get paid back?
and if you happen to be the parent who is supposed to pay, and you decide or have reason to believe that the other parent isn't using those funds for that child, it's abuse, it's neglect, what is it, and what do you do about it?
There's no court that's going to ask that you provide an accounting for the expenditures of the child support. If you're paying for curtains on a house, is that the house the child lives in? If you're paying a rent payment, that's the house the child lives in. If you're making a car payment, the child goes in the car. If you're buying drugs, that's a different story.
However,
This is very interesting,
and,
isn't it?
and just, we hear it all the time. I pay child support and my wife is going on a trip. I don't want to give her money to go on a trip. Well, money is fungible. Your child also has to have electricity, food, clothes, all of those other things. Your money isn't paying for that trip. Your money is paying for the clothes, the food, and all the other things the child needs. The court is not going to look at your child support is being wasted if the parent goes on a trip or something. Jackie has a point. If money is being used to buy drugs and other things, there's another issue there. That's the custody of the child and the child's well-being.
Yeah, but the courts are not going to order an accounting. A lot of times we'll get new clients in the office and they'll say, I want an accounting of every penny that's paid towards child support. It's not going to happen.
No.
Will it happen that apart from that support, whatever the amount is, the amount's given, and one parent says to the other, we need $200 for the new sneakers that Johnny needs, and dad gives, let's say dad's the one who's paying, he gives the $200, the kid still doesn't have the sneakers. Does this end up causing enough of a stir that the father has a legitimate beef to then question all the things that you say aren't supposed to be questioned?
Well, you have to look at the court order, because the court order provides that dad only pay child support, not for sneakers. Well, then, you know,
Right.
you just lost out on $200.
Those things are considered part of what you're paying child support for, clothes, sneakers. Now, a lot of times a court order might say, I'm going to pay child support, but I'm going to pay a percentage of the extracurricular activities, the soccer camp, the other programs that the child might be in, camp. We're going to split those equally. That's a different story. You might be entitled to say, I want to see the bill from the camp before I pay half of it. If you're paying for something specific, then you might be entitled to some more information.
How reasonable. That makes so much sense.
It's the way it is.
Well, we have to cover our grounds when we prepare settlements in those cases. Even with uninsured medical expenses for the children, we have to make sure that we put in writing that the parent who made the payment has to keep a receipt, provide the non-custodial parent with a receipt. Non-custodial parent has 30 days to pay. We used to put a reasonable amount of time, and then you end up litigating the issue. What's reasonable? 30 days to pay. Okay. Some cases you don't have to do that because the parties are cooperating. In some cases you do.
It's like visitation. Some cases you say reasonable rights of visitation, they're fine. Other cases you have to spell out Martin Luther King Day and every other day of the year.
In the short amount of time that we have left, you mentioned briefly earlier that you think that they should be changing or lowering the amount before there's a trigger. Considering there's a backlog of cases, they can't enforce them. Do you want to touch upon that briefly in the short amount of time?
I think if they lower it, then they have more the ability to enforce it. But I also think if you had staffed an office with attorneys that do nothing but collection, maybe 2 or 3 attorneys that do nothing but pursue child support arrearages, instead of going and establish child support arrearages, you may be able to resolve some of that problem.
A quick yes, no. Do you think that the threat of jail is likely to work to put someone...
I think it works if people are called into court and they actually see someone sent to jail who doesn't pay child support.
You agree?
Oh, yeah.
Good.
There's a message there.
Well, I think that we've brought up a lot of topics here. There are things that are still debatable. We thank you for tuning in to Legal Matters. We hope that these issues have helped you in some of your decisions and some of the things that you need to check out further. We thank you, Jackie Grasso, and David Bazar from Audette, Bazar, Cordeiro, Grasso Law Firm in East Providence. We also want to thank Jesse Dufault, our wonderful producer who has been taking care of us here at Full Channel. If you have any questions or suggestions about topics, we still say legalmatters@fullchanneltv.net. Thank you for tuning in. We hope that you will stay tuned and continue to watch as our discussion of legal matters will continue.